The main purpose of the terms of use is to protect you from liability for how users use your website and anything that can go wrong as the result. I will talk about main provisions that accomplish that. First of all, disclaimer warranty and limitation of liability clauses that you have seen on other websites, usually in all caps. They state that your website is provided on an as-is basis to be relied at user's own risk. There are no warranties of any kind, no warranty of fitness for a particular purpose, no warranty of accuracy of information. Limitation of liability limits your liability as far as money and in time, meaning it can say that people cannot sue you for amounts more than the fees that you have received from them in, let's say, the last 3 months. Or it can be limited to, let's say, $50. If they haven't paid any fees, then 0. It can be limited in time if you say that no lawsuit or other action can be brought against you after more than, let's say, 6 months from the date something went wrong. Without those clauses, your liability can be significantly higher if consumer law provides for higher liability, or state law, for example, gives more time to sue you based on the statute of limitation. So those are the two general clauses, the disclaimer of warranty and limitation of liability, but normally you would also want to tailor them more specifically to your website. For example, if it's the NFT, cryptocurrency, trading, financial advice, financial information type website, you would want to disclaim to say that this is not professional financial advice. It is, again, to be relied at your own risk. Past performance is not indicative of, is not a guarantee of future results, and so forth. If your website has to do with some kind of medical information, for example, nutrition, you advise people how to eat, it's a fitness website, yoga, you would want to make sure you're protected from liability in case people injure themselves. So to accomplish that, state that this is not professional medical advice and people should not rely on any information provided on your website as a substitute for diagnosis or as a cure for anything. Always seek advice of the qualified medical professional. You also want to disclaim liability for not only your content, but also third-party content that appears on your website. If you're using, for example, a plugin for a forum, chat, you would want to say that third-party services that you use have their own terms of use, their own privacy policies, and ultimately their service is separate from yours. So if anything goes wrong from the third-party service, liability goes to the third party away from you. Other important clauses to have: acceptable use policy. What can people do and what they cannot do on your website? Obviously, they should not be allowed to spread viruses, do other harmful things, but also things like registering duplicate accounts. You may not allow registration under a certain age, and so forth. So think about the acceptable use. You may want to limit sharing of some of your content or content provided by other users. Speaking of content, of course, IP ownership would be the next important thing to protect you from liability. IP ownership states what is yours on that website and what is users. IP ownership clause would give both you and the users some peace of mind, where you say this content is mine and these are the terms upon which you can use it. For example, maybe you don't want to allow people any commercial use. Maybe you don't want to allow to share any of the site pages and so forth. And their data should remain their property. If the IP ownership clause states this, people have a lot of peace of mind, particularly if they're providing personal information. Like, let's say their site has registration, profile, they're gonna give their birth date, photo. All of that would be governed by your privacy policy, but also in the terms of use, you would want to outline the legal ownership rights as far as their data, but particularly personal data, of